Hi, I've got a very important topic I want to talk to you about today in Georgia probate law, and that's the 3 phases that every estate is going to go through. And in talking about this, we'll be able to talk about an overview of how estates work in general from the very beginning when we open the estate to the very end when we're closing the estate because everything is settled and finished. My name is Eric Brohl. I'm the founder and CEO of Georgia Probate Law Group. We're a law firm and we focus exclusively on helping families after the loss of a loved one. Sometimes that means we're helping in peaceful situations where our main goal is to make sure that everything is done correctly and properly and the estate settled right. Or we also help in situations that are less peaceful where there may be a dispute or litigation over an estate and trust matter. But let's jump into our topic for today. So today, as I said, we're going to talk about the 3 phases that every estate goes through. So to start with, we're going to draw a representation of our estate up here, and then we'll put our first phase in, which is the appointment phase. And so in the appointment phase, our main goal is to get someone appointed who's able to represent the estate and act on behalf of the estate. We call that person an executor if there's a will, and we call that person an administrator if there's not a will. So to get that person appointed, we need to file a petition with the probate court. And that petition is going to have a number of disclosures that we have to make, and we may need to file some additional attachments with it. When we're in this phase, there's 3 things that I'm primarily concerned about where we can make a difference in how the overall estate process goes. We can make a difference in how expensive it is, in how involved it is, and how long it takes. Those 3 things are we required to file a bond? Are we required to file inventories? And are we going to have expanded powers, or are we going to have limited powers for our executor and our administrator? If we have to file a bond, if we have to file inventories, if we have limited powers, that means that this process is going to be more expensive and it's going to take longer and it's going to be more involved because we're going to have to be going to court more frequently. If, on the other hand, we're able to waive bond, we're able to waive inventories, and we're able to get expanded powers, that means the process is going to take less time, be less involved, and less expensive because we only have to go to court once at the beginning to open the estate and once at the end to close the estate, and we don't have to file a tedious inventory or go pay for a bond. So if everyone's on the same page, that's the way we prefer to do it. We filed our petition, we either have asked for those waivers or we haven't, and now we've gotten a document back from the court called letters testamentary or letters of administration. That's actually a court order that gives our executor or our administrator the power to act. Quick note, before you get that order, no one has the authority to act on behalf of the estate, so please don't go and try to start doing things before then. That's how folks sometimes find themselves in trouble. But once we get that document back, we're ready to move to the second phase. That second phase is called the administration phase. In the administration phase, we are primarily concerned with settling the estate. That's where we do the work of the estate that most people think of as settling the affairs. That's where we figure out and we make a decision about whether we're going to keep property or sell property. That's where we figure out who does the estate owe money to, and we have to make sure that those creditors get paid or otherwise addressed. We also figure out who's going to get what in the end. So what that means is under the terms of the will, who does the will identify as supposed to inherit property? Or if there is no will, under state law, who are the heirs that are supposed to inherit property? One tricky thing that often comes up in this phase is the idea of whether or not we're going to sell property. A lot of folks don't realize sometimes you can be forced to sell property if there's not enough cash in the estate to pay the debts unless we can deal with those debts some other way. So that typically comes up in a situation where we could be forced to sell the estate home. Oftentimes families may not want to do that. So there's ways around that, but I want to highlight that as a potential issue to be aware of. In the second phase, we're going and we're working with the property, we're selling the property, we've paid the creditors, and now we're at the point of making a distribution to the family members, making their inheritance distribution to them. Once we're ready to do that, that tells me that we're now finished with the second phase and we're ready to move to the third phase. The third phase we call distribution and discharge. So in the distribution and discharge phase, our main goal is to close the estate. So there's a few things we're going to do. First, we're going to confirm that we've calculated the distributions correctly. We're going to confirm that if there's any kind of executor's fee or administrator's fee, we've calculated that correctly. We're going to make sure we've paid all the creditors. Then we're going to make those distributions. Then our attention turns to closing the estate. Why? Because at this point, most of the time, our executor or our administrator is primarily concerned with how to finish this and also how to not have to look over their shoulder in case anything happened or didn't happen that should have while the estate was open. So Georgia law provides two ways to close an estate. Under one of those ways, we ask the court to simply close the estate. Under the other way, we ask the court to close the estate and put a liability shield up protecting our executor or our administrator. So we obviously want to use that second way. There's a number of disclosures that have to be made when we file this petition. We want to make sure that we make those disclosures correctly, because if we don't, it could put our liability shield at risk and make it ineffective. That's the estate process from start to finish. We start by getting someone appointed. Then we move to settling the estate, a lot of work there, and then we move to closing the estate. I hope this has been helpful to you. If you have any questions or you want to talk about your own situation, please feel free to reach out to our office. We'd be happy to have a consultation with you. Thank you for watching, and I hope you got something out of this. I appreciate your attention.